Good afternoon. It is March 6th, 2021. I am Andre Smith, your host at the Economic Justice Law Review for our periodic scholarship reviews. And today we've selected another very important piece that's been recently published by the scholars Neil Buchanan at the University of Florida and Michael Dorf, who is at Cornell University, and they have a new piece out called A Tale of Two Formalisms, How Law and Economics Mirrors Originalism and Textualism. And for those that know me, law and economics on the one hand, statutory interpretation on the other, two things that I really get into and push my own particular narrative upon with respect to racially asymmetric market imperfections. So of course, it's going to circle back to that at the end. But for right now, that's what we're going to review. A Tale of Two Formalisms, How Law and Economics Mirrors Originalism and Textualism by Neil Buchanan and Michael Dorf. It's found it's going to be forthcoming in the Cornell Law Review, the 106th edition or title. Guess the page number will be upon us shortly. Professor Dorf is also a professor at Cornell University. So anyway, the thesis, let's see, let me sure I can read it to you guys. But the thesis is two leading schools of thought among U.S. conservative legal elites, law and economics, and originalism and textualism, both purport to use their formalist structures to guide analysis in ways that are objective, substantially determinate, and apolitical. Because they rest on very different theoretical underpinnings, law and economics and original and textualism should only randomly reach similar policy or legal conclusions. After all, law and economics implements neoclassical economics, a theory of utility maximization, whereas originalism and textualism is a theory of semantics. Yet as practice, law and economics and original and textualism rarely result in conflict. Accordingly, conservatives use law and economics and originalism and textualism to obscure the role of normative priors, perhaps even from themselves. And editorially speaking, that is the essence of what is called critical legal studies, right? The idea that judges and legal actors operate from normative or personal or policy preferences and priors, moral foundations, et cetera, come up to correct or just results and then defend it by using supposedly formal structures. So again, the essence of critical legal studies, as stated here, conservatives use law and economics and originalism and textualism to obscure the role of normative priors, perhaps even from themselves. Liberals could use the same techniques for different results, but heretofore generally have not, instead mostly settling for counterpunching against charges of result orientation. That last part, I will say that to me is one of their less appealing conclusions. This idea that the left has, quote unquote, failed to create an economic construct that produces left wing or liberal results or progressive results derived from economics and originalism and textualism. I think that's a less appealing conclusion for a couple reasons. They talk about well, we'll leave that to say, but I'll just say that for right now, given the indeterminacy and manipulability of both originalism and textualism and law and economics, these authors believe the left has failed to produce counter narratives within those constructs to insist upon progressive results. Again, I'm going to critique that a little bit later because I find that to be a little less appealing than some of those others. And also, I'm going to offer my own method for producing a counter narrative within originalism, textualism, and law and economics that may produce what some people call progressive results. Well, I'll be interested to see if Professors Dorf and Buchanan get a hold of this. I'll be interested to see what their reaction to that is. So into their paper, Buchanan and Dorf first set out to prove that economic efficiency is an empty term and thus manipulable. However, I don't think that they prove that efficiency is perfectly manipulable, and that's important. The fact that it has some hook or some objectivity, I'm not inclined to be binary and say that all things are either inefficient or efficient, just as I'm not willing to say that they're manipulable or not manipulable. There's degrees in between. So while there is no such thing as efficiency, I definitely agree with that. Naked and by itself, as it's an empty term by itself. But one option can be more or less efficient relative to another option towards a specified goal. So that is where efficiency to me is not necessarily perfectly empty. Manipulable, yes, and not perfectly so. To the extent national wealth maximization is a legitimate goal, it cannot be the only one, according to many scholars, including Buchanan and Dorf. But they point out that the efficient result does not equate to a just result if the baseline or status quo or current distribution of wealth is unjust. Now, I know they won't use the term unjust, but I'm sorry, it wields its way when you're talking about one preferred outcome over another. We're talking, for lack of a better word, about which one is more just. A current equilibrium can only at best be described as efficient, assuming that the ill-gotten gains of slavery, for example, were properly distributed. For the distribution of wealth and therefore proper economic equilibrium would be markedly different had Black people been properly compensated for their labor. And we don't have to just use slavery. You can use any dynamic from large to small to say that if any one thing that should have happened in the past would have happened in the past, things would be different now, and the correct equilibrium point would be different today. So that is basically their point about saying that efficiency is an empty term, because what is efficient right now is based on previous inefficiencies or injustices, whichever way you want to attack it. So furthermore, and similarly, they contend that the static efficient result does not equate to a real or true efficient result if the baseline or status quo or current legal and normative rule structure is inefficient to begin with. Please correct me, for those that know, for those professors or anyone else, if I have that interpretation wrong. But a current equilibrium can only at best be described as efficient after assuming that all the laws and regulations currently existing also produce perfect market efficiency. For the efficiency calculation regarding a new law or rule would be markedly different if the minimum wage were set at what it should be, and that's regardless whether it be higher or lower. Right? The after effects on the distribution of goods and services would just be different. And therefore, that would be the correct equilibrium price and supply, et cetera, versus what we have today. So for someone to say that civil rights law would produce inefficiency, well, is that true, considering that where we are cannot correctly be described as the efficient, naturally, truthfully efficient starting point? So my critique of this section, as you just heard me say, as I described it, discussed it, my critique of this section is that although Buchanan and Dorf show that efficiency does not exist standing by itself, they do not convince me that economists cannot possibly determine reasonably and roughly whether one option promotes national wealth more than another option. That's one of the hooks of conservatives when it comes to law and economics. Their argument is that justice is amorphous, justice is ambiguous, and everybody has different policy preferences, but that the one thing that perhaps 100% or maybe 85% or 90% of Americans can agree with is that the country should be more wealthy than less wealthy. So whether one option promotes national wealth more than another option, given that the majority of people do not care about the society we could have versus the one we are dealing with now. Buchanan and Dorf fall victim to their own criticism when they ask for a perfect baseline to produce abstract efficiency when the goal of law and economics is national wealth maximization rather than that abstract efficiency that they discuss. Yeah, people throw out the term, this is not efficient, but what is left unsaid is the argument that it is a drag upon the economy and that will produce less wealth than greater wealth. Now, again, I know the retort would be that each specific item or dynamic within the national economy, to the extent they are inefficiently chosen, we can't predict whether it would actually work against it. But anyway, if we're going to discredit the goal of national wealth maximization and describe law and economics as empty with respect to attaining it, I would offer that one could invoke the economic concept of time inconsistent preferences to argue that efficient rules relating to any two discrete dynamics could often, two or more two discrete dynamics can often work against each other, even if both purport to promote national wealth maximization. Think of a household, and one spouse um, says that what we need to do is start a business, and starts doing all the things that are efficient towards creating that business, where the other spouse says, no, we need to take our resources and turn ourselves into investors, and spends all their time and resources towards investors or some other, I don't know, Jack and the Beanstalk. The point being, their actions could complement each other, right? Or because they are slightly different goals, both of them supposedly towards wealth maximization, they might be pulling against each other, even though what one spouse is doing is efficiently going right, the other spouse is efficiently going left, and yet they are not increasing the wealth of the household. They're actually fighting against each other by expending resources that don't necessarily complement each other. So this idea of inconsistent preferences can be used to attack the idea that efficiency with respect to one discrete legal rule or activity necessarily produces a greater national wealth. Now, ultimately, Buchanan and Dorf, once again, they cogently show how manipulable law and economics can be, but not perfectly so, in my opinion. Similarly, and this is what really makes their work, makes them two of, Neil Buchanan is one of my favorite legal authors. Let's not mistake that by my critique. When it comes to dismantling formalism, Neil Buchanan is it, and I'm a fellow tax law professor, so of course I got to support those within within my own construct. But similarly, Buchanan and Dorf cogently show how manipulable originalism and textualism can be, but not perfectly so. And I think they do a better job on this one. Well, I'm not gonna say they do a better job, but I think originalism and textualism is a little bit easier to show to be manipulable and so-called empty than law and economics or the term efficiency. However, there is still some concreteness. There is still something there when it comes to textualism, and I'll mention that in a minute. Uh, Buchanan and Dorf spend considerable time showing how three conservative justices of the Supreme Court dissented in Bostock versus Clayton County, which is the issue of whether the Civil Rights Act includes protection of gay and transgender employment rights. They dissented in Bostock versus Clayton County, even though most scholars seem to agree that originalism and textualism strongly favored LGBTQ rights in that statute. And yet the three conservative justices that argue most strenuously for originalism and textually somehow missed the boat. So they use that to prove, or at least suggest strongly, that what's going on is the primacy of those normative priors, those moral foundations and personal preferences over this construct used supposedly to determine what the law, quote unquote, is. However, as a former tax court clerk myself, I am aware of judges who decide arcane and boring cases over tax matters, over which a typical judge may have no ideological skin in the game, by using textualism simply because they honestly feel that it is the best way to not be overturned by the circuit courts of appeal. right? That if you want a circuit court of appeal to look at your thing and say that's a reasonable way to approach the law, even though now we could put in the idea that circuit courts are supposed to review de novo. We could also then argue about whether the tax court should be reviewed de novo, of which I've written a paper that says they ought not be reviewed de novo, that they should have deference. Regardless the point, um, judges do believe that their opinions are read and considered, regardless of that de novo means afresh, and that the way in which they can protect themselves from being overturned is to use latch onto a textual hook. More than that, you could have the argument, and I actually know certain judges that do, who argue that for fairness purposes, for anti-eliteness purposes, the people who pay taxes should be able to read the law and follow it as they understand it, because the people, and we're not talking about wealthy people, but just your average person, does not have access to the intents and purposes that Congress may have held, right? You could say that that doesn't matter, but at the same time, you could say that it does, and be reasonable in insisting so as a judge that uses textualism, the idea of plain meaning and what is understood by the audience, as their strongest factor within their deliberative formula. And since uh, uh, Buchanan and Dorf set out to prove that original and textualism, honestly done, ought not point in any ideological direction, there does not seem to be much of a cogent objection to the way in which a tax court judge I am describing might operate by committing to textualism, done correctly. Uh, Buchanan and Dorf are at their best in this work when they provide evidence that judges who use law and economics and originalism and textualism come to the same conclusions far more often than they should, right? This idea of promoting wealth maximization versus following what the people understood, right? Those two things have absolutely nothing to do with each other, and should agree, so they should agree with each other and disagree with each other as much as any other construct would, but they always seem to comply. A recent and Buchanan and Dorf are not the only ones to talk about this. They're not the only ones to notice this. There in 2020, there was a very good Yale Law Journal article that offered the two-step framework for how law and economics and originalism and textualism are deployed by conservatives, with originalism and textualism utilized to produce conservative results in rights cases, while law and economics is deployed in cases regarding commercial results. You can see Britton and Purdy from Columbia, Grewal from Berkeley, Amy Kapczynski from Yale, and Rachmana from Brooklyn. And they're building a law and political economy framework beyond the 20th century synthesis. What they're calling the 20th century synthesis is just what I described, that law and economics being deployed in commercial cases, and originalism and textualism being deployed in rights cases, both towards producing conservative results. Their paper was found in the Yale Law Journal last year, 2020. Buchanan and Dorf are after they're also after, so this is my critique. This is, to me, their less appealing observation. The point about ONT and LNE being empty, agreed. Manipulable, agreed. Perfectly empty and manipulable, not as much agreed. And here I fall off a little more, where they ask that Buchanan and Dorf are after a counter construct for the left, one that is manipulable at the same time it purports to offer objectivity through mathematical rigor. And I guess if you're on the left, and if you're truly a critical theorist, I guess the question is why? Why should they? If judges can't help but decide cases based on their normative priors, then it doesn't matter what construct you use, right? They're going to decide the way they feel. And so the way for progressive interpretations to trump or be prioritized is simply to have progressive minded judges, and they can write it up any way they feel. They can write it up through a critical, a law and economics framework, an originalism and textualism framework, some heterodox economic framework, any other type of framework, narrative from coming from the critical race theory department. You can write stories and books. If people's normative priors control how they decide, then the point of critical legal studies, I thought, was that yeah, whatever construct doesn't matter. Now, if we're conceding that law and economics and originalism and textualism have a popular um, hook, have a popularity in social circles that we want to embrace outside of just raw power to appoint progressive judges, then okay, well, let's try it. Or if we're saying that there, whatever remaining objectivity or determinativeness of either construct has to be dissembled by a counter construct. Well, here's one that I offer, right? To me, and I offer this always at the Economic Justice Law Review, you know that we discuss efficiency, not in the discrete manner of whether that particular item or dynamic produces the right amount of goods and services at the correct price upon a supply and demand curve. Our concern is about the structure of the market itself, right? That efficiency from a broader perspective, especially if we're talking about national wealth maximization. Here, we're talking about whether the structures of the free market have been degraded or not. The free market, as I was taught by neoclassical economists, was that the free market itself, in order to even exist, even just in order for the numbers to make sense as far as a prediction, that everybody in the market is a profit maximizer. Everybody is there is perfect competition. Everybody can enter any market they choose, leave any market they choose, which means everybody has the same amount of capital or requisite amount of capital, and not just financial capital, human, social, political capital. There's perfect information. How ridiculous is that? Perfect information about to be had, and that there are absolutely no transaction costs like pollution and crime, etc. So the idea, we know that those structures of the market are imperfect, right? They're not perfect, they're imperfect, right? So there, even though there's some truth to it, it's imperfect. We also, and that the government is authorized to, and Buchanan and Dorf will agree with this, and most conservative scholars will agree that the government is authorized to create laws and rules and structures both positively and negatively to enhance the structure of a fuller free market that can then produce efficiency, meritocracy, etc. Well, we know those imperfections in the free market are asymmetrical with respect to race. And we could also describe them often as asymmetrical with respect to gender and sexual orientation and nationalism, whatever. But as far as a critical race theory is concerned, I'm concerned as far as Black people concerned, but as far as people of color concerned, that the market structures are racially asymmetric. The imperfections are racially asymmetric. So if a rule, right? If one interpretation of a rule seems to exacerbate the asymmetrical nature of imperfect competition, if it exacerbates the asymmetrical nature of asymmetrically distributed transaction costs from on a racial basis, if they show that it exacerbates the asymmetrical nature of imperfect information, right? With respect to race, right? Then that is a market inefficiency that should be eliminated, because it, not just because it produces justice with respect to black people, but because it makes the market better. And when I say market better, what are we after? Some type of meritocracy, right? We have to go all the way there if we're talking about why law and economics and objectivity and all this stuff and interpretation is important to your average person who somehow links onto it, right? This idea of law as referee, right? If we insist on equal opportunity, if we insist that capitalism and neoclassical economics and free markets are the way in which that opportunity is availed to people, then we need to talk about the way in which those structures fail, and not just fail, but fail asymmetrically with respect to race or gender or etc. So those are the constructs I evaluate critical race theory and take what is usually presented in some other narrative and recharacterize them in terms of racially asymmetric profit maximization, racially asymmetric competition, racially asymmetric market information, racially asymmetrically distributed transaction costs. Okay, and that to me is the efficiency rubric that can produce progressive results through this objective, through objective analysis. All right, and then B, how do we get that injected into legal argument? I would justify the discussion by invoking the plain meaning of proper within necessary and proper as understood by NYU's Jeffrey Parsons Miller. Okay, what does that mean? When we talk about the necessary proper clause, that is in the Commerce Clause. 97% of congressional legislation is offered through the Commerce Clause to make the economy better, right? So we're already using that to inject our concept of racially asymmetric market imperfections. But how do we do that if textualism is out there? Well, Jeffrey Parsons Miller has a great paper written about 2010 or 2011 and argues that the term necessary and proper had been used in corporate charters in the 18th century plenty of times, both independently and together, and that proper, right? First of all, can we stop and say, first of all, necessary is not interpreted textually, right? It's not, we don't interpret necessary to actually mean necessary. It just has to be helpful or reasonable or logical, not what the plain meaning is. Anyway, but if we were to invoke the plain meaning, let's start with proper. Proper in those corporate charters used independently of necessary seem to suggest, according to Professor Parsons, that corporate rules and bylaws and regulations could not be implemented or interpreted in a way that disadvantage is one class of shareholders against another, right? The B shareholders versus the C shareholders, or whatever the case may be. And the analogy to the melting pot of America should be strong. That proper in this in the legal context should mean that laws are passed under the Commerce Clause should not be interpreted or implemented in ways that unreasonably disadvantage one race versus another, or one class of citizens versus the other. And the way we would determine that disadvantage would be whether the distinction we would, or construct we would use, would be whether the structures, it makes the structure, exacerbates the asymmetrical nature of the market imperfections, right? All right. So A Tale of Two Formalisms is a hot paper. Statutory interpretation, law and economics, critical theory, all wrapped into one. I highly, 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 highly recommend it. Don't take my criticisms and comments as disrespect. This is a phenomenal paper, especially for those. And again, we're in we have a new presidential administration. There's going to be a lot of talk about Supreme Court justices and what makes a great justice. And to understand how to attack or deal with originalism and textualism and the interpretation and whatnot to understand how that game works. I really think that those who are truly interested should read Neil Buchanan, Michael Dorf stuff, especially when they talk about the emptiness of law and economics. Um, Next up, our next piece, we're going to go in a different direction. This piece by Dion Rabouin of Axios is not a scholarly paper. It was actually basically a news article or magazine article, 10 myths about the racial wealth gap. But the way it's presented is so good as far as what those 10 myths are, has lots of data to back them up, and then comes to a rather what I would call Afro-pessimistic conclusion, right? And one that argues that the racial wealth gap cannot be resolved by independent actions of Black people themselves, and to close it requires legislation and intervention by society, i.e. the government. And while I agree that it cannot be closed, I think it says a little too much. And so I want to use this paper because the wealth of information is great, but they'll also draw a distinction between racial realism and Afro-pessimism. Afro-pessimism is going around now in Black Studies Department, this idea that racism is permanent in the sense that there will always be colorism, there will always be discrimination based on race, but I don't know that Derek Bell, when he wrote The Permanence of Racism, necessarily meant that white supremacy will always be permanent, right? And again, so to fluctuate on that scale of the racial wealth gap, that it doesn't matter whether it is widening or declining or staying stagnant, goes too far. And so those of us who consider ourselves racial realists, I think should distinguish ourselves from the pessimistic part. So I'm going to go, so I'm going too far deep into it. That's going to be the next article review, hopefully in the next week or so. Again, this has been, thank you for joining the Equal Economic Justice Law Review and our review of Neil Buchanan and Michael Dorf's A Tale of Two Formalisms, How Law and Economics Mirrors Originalism and Textualism. Hope to see you soon, and Hotep.